Arrested? Use these 8 rights to walk free. Miss even one right, and the justice machine grinds you to powder. Stay with me as we walk step by step through the survival checklist every defense lawyer lives by. First right, absolute silence. The moment officers say you're in custody and start questions, your words can convict you. Miranda warnings exist to tell you talking is optional, not mandatory. If they forget to warn, prosecutors must scramble to replace your missing confession. So breathe, calm your pulse, and answer every question with quiet or with one sentence. I choose to remain silent. Second right, counsel. The Supreme Court held that the accused deserves a lawyer whether or not they can pay. Public defenders try thousands of cases a year and know local judges, prosecutors, and plea patterns. Simply say, "I want my attorney." Then stop explaining anything. Police are trained to keep conversation casual, but casual talk becomes court evidence. Once you invoke counsel, officers must halt interrogation until counsel arrives or you restart it. So don't restart it. Third right, reasonable bail. The 8th Amendment forbids judges from locking you up behind a price tag you can't possibly pay. At your first appearance, the judge must set conditions with reasons. If bail feels sky high, your lawyer can demand a bond review hearing and require the state to justify every dollar. Bring wage stubs, family obligations, and community ties, evidence that proves you'll show up to court without ridiculous cash guarantees. In many jurisdictions, alternatives like ankle monitors or daily check-ins replace cash bail entirely. So, ask. Fourth right, the speedy trial clock. Justice delayed is justice denied, so courts weigh 4 factors: length of delay, reason for delay, your demand for trial, and prejudice to you. File a speedy trial motion early so the record shows you objected. Each continuance you grant can restart the clock, so weigh convenience against leverage. If the delay crosses constitutional lines, judges can dismiss the case outright. Sometimes prosecutors refile, but witnesses disappear, memories fade, and your bargaining power skyrockets. Fifth right, full disclosure of evidence. Under the Brady Rule, prosecutors must hand over anything that might help the defense. Ask for police body cam, lab reports, witness statements, and disciplinary files. If the state buries exculpatory data, your lawyer can seek sanctions, jury instructions, or dismissal. Digital discovery portals now timestamp each uploaded file, so track what arrives and what's missing. Always read your own discovery. You might spot contradictions faster than a busy attorney. Sixth right, confrontation. You get to face your accusers and test their story through cross-examination. Anonymous statements, recorded hearsay, or affidavits often crumble once the witness sits in open court. If the government tries to substitute paper for a living witness, object immediately. Remember, no face, no case is more than a rhyme. It's a cornerstone of fairness, dating back centuries. Good cross-examination doesn't shout. It guides jurors to doubt with short, leading questions. Seventh right, probable cause review. Police can't stash you in a cell for days, hoping something sticks. A neutral judge must promptly confirm facts supporting the arrest. If officers exaggerate or omit key details, your lawyer can challenge the warrant and suppress tainted evidence. The hearing record also preserves their story for cross-examination, so take notes on what they claim. When timelines slip, courts often reduce charges or toss minor counts altogether. Eighth right, clear invocation, the safety net tying all rights together. Courts rule that silence alone might be misunderstood. You must speak to stay silent. Say the full phrase, "I invoke my right to remain silent," and to an attorney. Then lock your lips and let time work for you. Recording that sentence on your phone or repeating it in front of witnesses adds extra insulation later. Let's cement the list with a fast mnemonic: silent, lawyer, bail, speedy, Brady, cross, cause, invoke. Repeat it 3 times now. It could save you years. Picture a real-world stop. It's midnight, blue lights behind you for a busted taillight. You pull over, hands visible, engine off, window down halfway. The officer asks where you're headed. You respond politely with license, registration, and nothing else. He smells alcohol, orders you out, and finds an old bench warrant. Cuffs click. Inside booking, detectives start casual small talk. You choose silence and request counsel. Booking officer records the request. Interrogation ends. Hours later, your public defender argues the warrant was entered in error and bail should be personal recognizance. Judge agrees. You go home by sunrise. Days pass. Discovery drops. Body cam shows the breathalyzer never calibrated that night. Your lawyer files a motion to suppress the stop and dismiss the charge for lack of evidence. Prosecutors, short on proof and facing speedy trial deadlines, offer a tiny traffic fine instead of a drunk driving conviction. Because you shut up early, the evidence gap forced their hand. Now, practical habits. Carry a small card with lawyer's number. Note every badge and unit in sight. Write timestamps the moment travel restrictions begin. Use auto-upload apps so videos survive phone seizures, file discovery, and speedy trial motions as soon as counsel enters appearance. Never sign blanket consent forms without reading every line. Strengthen your paper trail because courts respect documents over memories. Quick recap. Stay silent. Demand your lawyer. Challenge bail. Push for a speedy trial. Collect Brady disclosure. Cross-examine. Insist on cause. Formally invoke and zip it. Your rights exist, but only you can deploy them in real time. Save this video, share it, and keep that checklist within reach. Your next click could free a friend or you.